Would have been more plain in the world than that he was just waiting for this opportunity.
All right, good morning, everybody. I apologize, I'm a little bit late. We are on Twitter Spaces simulcasting. We are on Rumble at Uncle Jonathan 6 a.m. That is 6 like the number 6. And I am halfway through my first cup of coffee. Today we are going to be talking about how supreme is the Supreme Court. And what I started off with there was a clip from a very old, reminds of one of those videos we used to see when we were in school. What I started off with there, and with the old film projector, but that is a scene where Thomas Jefferson has received basically a summons, whatever you want to call it, from the Supreme Court in reference to the Marbury versus Madison case. So Madison was the Secretary of State, and let me talk about how all this. Well, let's talk about why this is important. So I listened to doing my research. I found out that this is one of the first cases taught in constitutional law, and why it's important is because this case actually is the precedent for what happens today when we have cases and we wait for the Supreme Court, and we all know the cases Roe versus Wade. There's been cases with like gun laws that are passed regarding like pistol braces or bump stocks or all kinds of things. And we've all probably had at least one or two cases in our life where we were interested or we were told that the Supreme Court ruled it constitutional or unconstitutional, and therefore the law either wasn't valid anymore, couldn't be enforced, or the law stood even though people disagree with it being constitutional. We basically, all of us in our lifetimes, excuse me, have lived under a system where if any law was challenged enough in the courts, it would eventually get to the Supreme Court, who would be the final decision maker on if that law should stand. Well, where did that come from? How did that start? Is that in the Constitution? Surprisingly enough, it's not. The Constitution says nothing about the Supreme Court being the final judge or the final arbiter of these disputes. As a matter of fact, let's go to the Constitution and look at what it says. And then we'll get back to Marbury versus Madison and why that's important. So if you look at the actual Constitution of the United States, it really doesn't say a lot. And that's part of the beauty of it, is that it is flexible enough, or it doesn't say too much that we've been able to do this. So Article 1 of the Constitution starts off with creating the legislative branch, Congress, the Senate, and the House of Representatives, which I think is important because this is the branch that probably is considered the most powerful, or should have been by the forefathers, right? This is the branch that directly represents the people. This is, basically a large committee of people that are voted, and then two different types of committees. One that's only has two representatives per state, and they're there longer, and another one that changes out every 2 years and is done more proportionally by population. Then you go into Article 2, which creates the executive branch. Again, a very powerful position, the president, but by no means, right, is it a king or a monarch. And so we got the legislative branch, we got the president, the executive branch, right, and their duties. And the last branch that's created in the Constitution is the judicial branch. And here's what it says. The judicial power of the United States shall be invested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, meaning they haven't been impeached, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. It goes on to section 2, talks about the jurisdiction of the judicial branch, and basically what we consider today all federal matters. Excuse me. Section 3 goes into treason. It says Congress shall have the power to declare the punishment treason, but no attainder of treason shall work. Blah 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 during the life. Okay. All right. So section 3 appears to. Let's just skip that for a moment because I don't think it's important. And then the rest of the Constitution goes into other articles. But the important part is Article 3. Right here, it's very short. It's just these 3 sections. Talks about the judicial branch. It doesn't say that they, anything about them being the final arbiter of the constitutionality of any laws. As a matter of fact, there's a bit of a hold there on the judicial branch from the legislative branch, as it says that the legislative branch has the obligation to create laws that will structure these inferior courts. Doesn't even say how many justices should be on the Supreme Court, which at the time of Marbury versus Madison was 5. It was 6, and they'd reduced it to 5. Today we have 9, and we often hear talk about one party or the other, maybe especially the Democratic Party these days, maybe in the future adding more justices, and this can be done. So basically, Congress has to pass a law that will structure the whole inferior system, but the whole federal court system. But at the end of the day, the Supreme Court sits at the top. And in the time of Marbury versus Madison, it's very interesting that there was only like three circuits. Basically, the whole federal court system was split up into 3 sections by regions. And when they had 6 justices, so 2 of the justices basically just heard appeals from the lower courts. And that was kind of their job. It wasn't the idea that the Supreme Court could rule on the constitutionality of something had not happened until 1801 with Marbury versus Madison. And so how we get there with Marbury versus Madison is while the Supreme Court, and this is how I came upon this, was I was researching the Sedition Acts, and I read something about Thomas Jefferson and his feelings that each branch should only be able to decide the constitutionality of matters for itself. For example, he felt that the executive branch should determine if, for their actions, if they're constitutional or not. The legislative branch the same, and the judicial branch the same. He didn't think that one branch of the government should be able to tell the other branches what you're doing, the law that you're enforcing, or the way you're enforcing the law is unconstitutional. Just like the executive branch had no right to tell the judicial branch the way they were judging the law and interpreting the law was unconstitutional. He thought every branch should be responsible for itself, and that the checks and balances would be upon each other, right? By basically outweighing, like each branch would be independent, but if 2 out of 3 branches saw the constitutionality one way, then there really wasn't one that the one dissenting branch could do. Almost like the way the Supreme Court decisions work now, right? If 5 of the justices think that one thing is constitutional, The other four really don't have any recourse except to write a dissenting opinion, which basically says, I disagree and here's why. So the idea that the judicial branch could rule and say this is unconstitutional and therefore this law that Congress passed is null and void, or that the executive branch must do or stop doing something, was a relatively new concept. This had not happened before until Marbury versus Madison. Now, the way it comes about is kind of interesting, but really not important as what happened. And the way it comes about is that you had the Federalist Party and you had the Democratic Republicans. And the Federalist Party was the party of John Adams, our second president. And let me make sure I got this right here. John Adams was the second president, right? Let's see. List of presidents. I need a producer. Because I can't just research all this stuff. Okay, let's go back here. Yes. Our first president was, yes, George Washington and John Adams. George Washington, I don't think, was really interested in parties. He was scared of them. So, really, the politics start with John Adams, who's our first president. And John Adams was a member of the Federalist Party. And the Federalists, the best way to think of the Federalists, I think, is they were kind of the old establishment, but there was no establishment, right? But there were people that were leaders in the countries and in the colonies. But their view was kind of the old establishment should kind of become more stable. There should be a stronger federal government. We did have the Articles of Confederation, which was weaker as far as a federal government than the Constitution. So the Federalists were kind of the ones that were pushing for a stronger federal government to kind of, instead of make us 13 separate countries, which were 13 states at the time, that were just kind of loosely connected, make us a little bit more cohesive. And they thought that it was necessary. And they thought really the way things, it should be kind of hard to change things, a little bit harder than it was. The Democratic Republicans thought that really trusted the people, and that being through the representatives in Congress. They really thought that if Congress, saw something that's constitutional or unconstitutional, or Congress saw something that needed to be done or didn't need to be done, basically if you had the votes in Congress, that's it, that's the way it should be. And so if you look at the Constitution, you can see where these two different points of views are, because the first article, the first branch created is the legislative branch. And I kind of see the argument that, and you could kind of at least see the perspective of the Democratic Republicans, where they thought the ultimate power, if there was ever a dispute about had the president gone too far, or had, was the court's ruling or a judge needed to be removed, that it should have laid in the power of Congress, because ultimately those people are there representing the people, the will of the people. And I guess the downside of that would be that you could have a lot of instability like we see today just with the presidency. You have one president, and then 4 years later you have another president from another party, and you have policies being completely reversed that really affect people and really get people upset or make them happy, whichever way you tend to feel about it. So there's two different philosophies here, right? One, kind of more of an establishment, authoritarian side of things. Another one that's a little bit more put everything up to the people through Congress and let that be the real seat of power. So how do we get to Marbury versus Madison? Well, in the last few days, and I mean even hours, they called them midnight judges. Basically what John Adams did is he appointed some really hardcore Federalist people in the government. So at the time, the federal courts, they called them, they're justices of the peace, were pretty much your entry level federal judges there. And he appointed a whole bunch. I think there's a total of 42 judges that were appointed. And the problem with the appointment was these judges would be commissioned for a 5-year period. So basically Thomas Jefferson was going to be stuck with all these judges that were going to basically interpret law and that more federalist mindset, where he is the first Democrat Republican. Remember, we've only had two presidents. And so Jefferson is coming in as the first Democrat Republican president. This president has a little bit more of, he feels probably like maybe the federal government, this whole thing is being hijacked a little bit and the power is being taken away from the people. So obviously Jefferson comes into this with a mindset of, I need to restore more, put more power into the people, and the way he saw it was through Congress. The other thing that was happening is that immigration, we're still arguing about today, right, was really taking off. And these immigrants that were coming over, a lot of them were, Irish, Scottish, Welsh, still probably Western Europe mostly. But let's be honest, all the bigotry and prejudices that we probably today as Americans don't see much difference between a Scotsman and an Englishman, or an Irishman and a Welshman. But back in those days, that was a pretty big deal. I've read in some of the early colonies, like Virginia, and some of the southern colonies, there were actual laws on the books before we became a country that prohibited Irish and Scots from immigrating. One of the things I read is that like Philadelphia became a big hot spot for Irish because they allowed Irish to immigrate, where Virginia didn't. It's kind of part of my story, is that a lot of my family came over before why Virginia was a colony, and they were from Wales. And now they probably came over as domestic servants, right? But they were allowed into Virginia because the English kind of said, well, we'll tolerate the Welsh. We'll let the Welsh come in. After all, we need maids and workers and laborers, but we're not going to, Irish are too far. So all these bigotries and prejudices, are still alive and well. I tell people it's kind of like college football, right? Like you're an Alabama fan, you're a Tennessee fan, you're a Texas fan, you're an Oklahoma fan. Look, these people all still felt connected to their ethnicity, and it was a lot bigger deal to them then than we think of it today. So all these immigrants that are coming over, well, the party that they tend to like is this Democrat-Republican party that Jefferson's heading. This party that thinks that the people should be the ultimate power, and that through Congress. So if there's something that, even if it's a bad idea, even if, everyone thinks this is against the Constitution, if the legislative branch says it's so, then it should be so. That should be the ultimate authority. So it's a very interesting, where do we put this thing? Because it's kind of scary, because I think you do have to have a way to ultimately settle these disputes, right? The Constitution says so little, which is part of the beauty of it, that you do have to have a way. So Marbury versus Madison, Adams goes and appoints all these judges, basically floods the zone, right? He's going to dump all these. He's thinking, look, here's going to be how I'm going to keep Thomas Jefferson from going completely off the rails with this, let the people, decide everything through Congress. I'm going to flood the zone. I'm going to appoint all these judges in the federal government that are all Federalists, and they're all going to be commissioned for a period of 5 years. These JP judges. We just read in the Constitution that basically said the judges are appointed for life. So I'm not really sure how that happened, where there was this commission that was needed. But at the end of the day, for these justices of the peace, maybe for all the federal judges, they needed commission. Either way, it was a period of 5 years, and there wasn't really much that Jefferson could do about it. That could be maybe another episode on how that works. But long story short, at the very last day before the power of transfer is to happen, Adams is sitting here, and they're just ramming through every judge they can, and knowing that these judges will be appointed for 5 years and they'll be stuck. And they had to have a commission, and most of the commissions got out except 4 guys. There were 4 guys that could not get their commissions. The commissions were written, they were sealed, they were drafted, they were sitting there on the desk in the Department of State, which was handling the matter. But the four actual guys that were going to be the judges could not physically get there to DC and pick up their commissions, which they needed their commissions because it was what proved that they had actually been appointed as judges. So that's how we get to Marbury versus Madison, because one of these four guys was Marbury. And he goes after the new president sworn in, Thomas Jefferson, and he appoints James Madison as the Secretary of State. And so these guys show up politely, and at least according to the film that I saw last night, and they simply asked James Madison, who's the Department of State, and they said, "Hey, look, we were running a little late. We apologize, but our commissions are supposed to be here, and we couldn't make it in time, but we'd greatly appreciate it if you would hand it to us." Well, James Madison simply says, "Look, man, that was the old government. I don't have your commissions. I don't know where they're at." Okay, so these guys are upset, right? They obviously feel that this is a political move, that, they're tossing away their commissions because they don't like the way that Adams appointed these judges and flooded the zone at the last minute. And heck, you know what? 38 judges is better for them than having 42. Okay, it makes sense. So what ends up happening is, and this is kind of a little bit contrary to the way I thought things were before, the Marbury and the other three guys end up filing a case directly to the Supreme Court, basically requesting the executive branch, Thomas Jefferson, the Department of State, the President, and the Department of State, to produce these commissions because they were duly elected. And what you see there in that clip was the Supreme Court basically issuing an order, basically as a summons, telling the executive branch that they need to come and show why they shouldn't be forced to produce this, because it's basically saying, hey, we're going to rule in this matter on this day. You need to come together, give them time to prepare and make their arguments. Whatever their defense is, we don't have them, we don't know where it's at, blah, 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 we don't want to reissue it, etc., etc. We're still a very young country. I mean, the country is really, George Washington's the first president, but he doesn't become president till 1789. So the country is still barely, 10 or 11 years old, even resembling anything that we know it under the Constitution. So the summons is received, right? And the Supreme Court gets the matter. And basically what ends up happening is the Supreme Court really has to look at how they received the case, and it should have gone through the lower courts first. And the Supreme Court could have easily said, we don't have jurisdiction because this isn't coming to us through the lower courts on appeal. Now, I don't know what the problem with that was. Maybe the lower courts were more slanted towards the Democrat Republicans. I don't know. But what the Supreme Court decided to do instead was to rule on the constitutionality of another rule of the Judiciary Act, which was Section 3. And so that's where this whole thing gets to not even be about Marbury versus Madison. And so, let's see here. Or Section 13, I apologize. Oh, I apologize. I got this backward here. Okay. So, remember when we start off at the beginning that yeah, here we go. Okay. So, remember when we started off looking at the Constitution and we started looking at excuse me, we started looking, when we started looking off at the Constitution here, we're just looking at it a few minutes ago. And remember how it said that Congress would have to set up the courts and pass a law? So at this time in 1801, they are operating under the Judiciary Act of 1789, which had just been passed 2 years prior, right? 1789, 1801, you get it. And part of that act had said that any case coming to Supreme Court had to first go through the lower courts, and the Supreme Court could only hear it on appeal, right? Okay. But the court, when they got Marbury versus Madison, could have easily gotten out of it by saying the Judiciary Act, and that part of it was Section 13, says that we can only get cases that were basically like an appeals court. We can only get cases if they've already gone through a lower federal court, a decision made, and one of the parties doesn't like it and appeals it, like an appeals court. And that's one way that cases still get through to the Supreme Court, right? Let's say you sue, somebody and you don't like the result, so you appeal it to your county level, you appeal it to your district level, you appeal it to the state Supreme Court level, and then after that, you can only appeal it to the federal level, and then you go to your federal district court, you go to your federal appeals court, and then only after appealing and appealing and appealing and appealing and appealing do you get to the Supreme Court, who's going to make the final decision. All right, so that's one route. And so the Judiciary Act of 1789 said that that's the only way any case can get to the Supreme Court. So when Marbury versus Madison is filed, it's what's called original jurisdiction. It was filed directly to the Supreme Court. So the case had not gone through those lower courts yet. So the Supreme Court could have easily leaned on the Judiciary Act of 1789 and just said, hey, look, we don't have jurisdiction over this case because it hasn't gone through the lower courts. It didn't get here on appeal. But instead, what they did see is that Article 3, Section 2 of the Constitution said that the Supreme Court was given original jurisdiction only in cases affecting ambassadors, public ministers, and councils in which the state should be a party. Okay. And basically, they said that the Supreme Court was given only in cases affecting ambassadors, public ministers, councils in which a state shall be a party. Had the founders intended to empower Congress to assign original jurisdiction, martial reason that they would not have enumerated this type. So basically, what happens is the Supreme Court rules that this section of the Judiciary Act is bullshit, that it is unconstitutional, and therefore that the law, at least this part of the law, was actually unconstitutional. So I'm confused now. And I apologize, guys, I'm still waking up. But the important part, whether the justices were saying that, again, this is why a lot of people don't understand it, but basically what ends up happening is, for this first time, the Supreme Court in the case says that a law passed by Congress was unconstitutional and therefore cannot be applied. Why is this a game changer? Because before that, the judicial branch didn't see it as their job to do that, to look at a law that was passed by the other branch, the legislative branch, and say that's unconstitutional. They also probably didn't see it as their place to look at any action or the way a law was enforced by the executive branch and say that that's unconstitutional. But the judicial review part, I think, is a little bit more limited to actually reviewing laws passed by Congress, which I think is probably the most powerful branch if you read the Constitution. It's the first branch. And this idea of, I'm still looking for this whole idea of three separate but equal branches. Well, I find three separate branches. I can't find anything in the Constitution that says that these three branches are equal. Maybe I'm wrong. Guys, send me comments. Show me where I'm wrong. Right? I'm not perfect. Obviously, my brain is half awake and I got started late today. But it seems to me that the Constitution intentionally puts the most power in the legislative branch, which is basically trusting the people, right? The president is one guy. The president wasn't even considered historically that big of a deal, not like it is today. And then you got the Supreme Court, and you got these judges that are appointed for life, right? And the ultimate arbiter of things, the decider of things, it seems that the Constitution was really intended to put the power in Congress, in the people. And I think that what we've seen is a lot of eroding of that over the years. Now, that could be good or bad. I'm not saying that, it's great. Look, you could have Congress decide, to pass laws that are absolutely ridiculous or, that go against everything I do. I mean, as polarized as we are, you're not going to make everyone happy today. That's pretty much obvious. You're probably much going to piss off half of the country, no matter what side you pick. But what was interesting about Marbury versus Madison is it said that the Supreme Court could actually review a law and declare it unconstitutional, where previously the Supreme Court and all the federal courts were simply ruling on the law as Congress had passed it. So I don't know if that makes sense. So, which kind of made the judiciary subordinate to Congress. Not to mention they could be impeached and removed, right, for political reasons. Which system would you like better? Would you like the judicial courts to be more independent and kind of unable to be touched? Or is it more important that Congress still have their hooks in the judiciary to where they're kind of a little bit more subservient to them? And the people who say three separate branches but equal are the ones that actually support, more of what we have now, where you have judicial review, where the judicial branch can actually override the legislative branch based on the constitutionality of a law. I don't see it as clear cut as a lot of people like it, but I think the important thing is to understand how we got here. And that's the importance of 1801 and Marbury versus Madison. Before that happened, really the judiciary branch was there to rule law on the law, and judicial review was not a part. Now I will say this, I did find instances or references to some of the states on the state level had already instituted judiciary review, so it's not like it was an entirely new concept. I think there's a lot of people maybe just felt it had to come and hadn't arrived to the federal government yet, who was very new. Remember, these state governments were colonies, so they had been operating, their own courts and their own systems for a long time before the country was established, and definitely a long time before the Constitution was established. So the federal government was still trying to get its legs out up from underneath it. But I find it interesting because obviously in this day and time, and we start with the Texas border crisis or whatever the issue is, we have these issues where we're waiting on the Supreme Court. How impactful has the Supreme Court been, right? Think about after the 2020 election. Will the Supreme Court take the case? Will they step aside? Should a state have been allowed to do mail-in ballots? Shouldn't they have? All these things end up on the lap of the Supreme Court. Is this really a good idea? Is this really a good idea to have these 9 people? Of course, we can change the number. Congress can change the number they can change it to, it doesn't say how many people. It could be 1. It could be 5,000. The Constitution doesn't say how many Supreme Court justices there has to be. So Congress can pass a bill changing the number of the Supreme Court justices. First of all, that. And then on top of that, do we really want to have these 9 justices just it seems like, I guess I feel like it seems like we're all a bunch of kids on the playground, and the Supreme Court is the teacher that we go to with every little single problem and dispute we have, right? Whereas I think the Constitution, there's an argument to be made that the Constitution was written in a way to say, you know, the teacher could say at some point, look, kids, don't come to me to fix all your problems. Y'all have to fix it amongst yourself, right? Is it Johnny or is it Bobby's turn to play on the seesaw? I'm not going to decide as the teacher. I'm going to tell you kids that y'all got to go and vote on it. And if the majority of you think it's Johnny's time, then it's Johnny's time. If the majority of you think it's Bobby's time, it's Bobby's time. Instead of coming to the Supreme Court whenever we can't agree on it as an arbiter to decide the final judge on it. Which do you guys think is better? Should the power be in the Congress, or should the power be in the arms of the judiciary branch? Right? So let's see here. I apologize, guys. Let me go here to live chat. And I'd like to hear your comments. Let's see. Let me just pop it out. All right. We do have the chat here. So I find it very interesting because I think it's very important for us, one, to know how we got here. And I'm sorry, guys. It's a little early for me. I overslept. You know, I watched the videos. I did my research last night, but I'm still confused on exactly what the Supreme Court was arguing about on the Judiciary Act. But let's just know how it ended up. They ended up saying that was unconstitutional, that the law that was passed by Congress was unconstitutional. That's what was different. They weren't saying, let's take the law that they passed and let me rule based on that, right? They were saying the whole dang law goes against the Constitution, which had never happened before. That's the beginning of judicial review. So it'd be like, you know, right? If somebody brought you into your local courts because you were speeding, right? And instead of the judge looking here going, well, what's the law say? Oh, if you're caught speeding, going over the speed limit, this is the penalty. The judge looks at the law and goes, this whole law is baloney, throws it out, right? Well, then that means what? That means that local judge can null and void any local law that's passed by the city council on how fast you can drive your car on the street or what the penalty is if you're caught driving above the posted speed limit. You see how that changes everything, right? Then the city council goes, well, wait a second, right? Any law that we pass, you mean the judge can just look at it and say it's unconstitutional and not enforce it? Yeah. So this was a huge shockwave to the Democrat Republicans. So what do you guys think today? I mean, look at all the issues we have. Abortion, gun rights, gun laws, right? You know, military, right? I think those, immigration. How can we forget immigration, right? So all these, you know, battles that we have that are brewing in the courts and that are working their way up to the Supreme Court, or some that are petitioned directly, we are programmed to think that Big Daddy is the Supreme Court, that these guys are the final decision makers of it. And the Supreme Court said. How many times have we had the Supreme Court said, the Supreme Court ruled? But it wasn't always that way. It wasn't always that way. And I really think that the Constitution, there's a reason why the legislative branch is first, and there's a reason why the judicial branch is last. They're Article 3. The legislative branch is Article 1. Right? If it seems like if there was going to be any branch of government established, it was going to be the legislative branch would be given the most power. Maybe I'm wrong, guys. Tell me, where does it say all three branches are equal? Because I haven't found it. So maybe I'm an idiot. I've looked. I'll continue looking. I see where three branches are separate, but I don't see where they're equal. As a matter of fact, I kind of see where Congress has their hooks in the other two branches, right? Congress has the power to impeach a president or to impeach a federal official, right? You see like what's going on with the Department of Homeland Security right now. Congress doesn't like the way he's doing his job. They have filed articles of impeachment. That's the legislative branch putting their hands into the executive branch and saying, you're screwing up, we're removing you. Are you going to tell me that's equal? No. The legislative branch has obviously got power over the executive branch. What? And so, the executive branch has some power back, but really it's just limited in vetoing a bill that the legislative branch can then override. Again, the legislative branch can impeach judges, right, and have them removed. Otherwise, they're appointed for life. It's pretty rare for them to do that. A lot of it is because the federal court system has grown into this monstrosity, and the federal courts are doing so much. Remember, the federal courts were not doing a lot back then. It was very, very limited, but we have so many federal laws now and so many issues that the federal courts are handling now that Congress can't get away with just impeaching everyone they don't like they tried to do in 1801, which the Democrat Republicans did push back. They did impeach a lot of judges and get them removed when they had the numbers in Congress. But I don't know if you could practically do that now because you need so many judges to be so time consuming. So I think the resistance to impeach federal judges is there just because it's just so hard to replace them. But that doesn't mean that the appointments aren't pretty much political or come down to party lines when they do come up and come available. But regardless, where should this power be? We hear all the time complaints about activist judges, and we hear complaints about all these fights we have over, every time there's a Supreme Court nominee, because we know how much that's going to affect. Where should we have that power? Where should that power be? Should it be in a guy appointed for life, and he's just appointed because of who happened to be president when somebody else retired or died? Or should that power be in Congress, which is made up of directly elected representatives? And a lot of them, all the ones in the House, change out every 2 years. All the ones are up for re-election every 2 years. And the ones in the Senate are up for election every 6 years. I don't know about you guys, but I think it sounds a lot more fair and a lot more, democratic, to use that word, and it's been kind of abused by the liberals lately. But I think it makes a lot more sense for that power to be in the hands of the legislative branch. So anyways, I'd love to hear your arguments for and against. Let's see, we've been rolling here now for, I can't even see the time, for quite a while here. And that's about all I got on that subject. News. I don't know if World War III started with Iran yet. I probably need to start covering more news. I might do that this afternoon or this later. But thank you guys for tuning in to Uncle Jonathan 6 a.m. I hope you found the whole argument of how supreme is the Supreme Court. I apologize for sleeping a little late. I have gotten through my first cup of coffee. I'm going to get through my other one. We will survive, but I just wanted to share that argument. How supreme is the Supreme Court? How did we get here? We got to think about how we got here. And at least, even if things need to change or don't need to change, or we agree or we disagree, let's know how did we get here. Let's know our own history, because I think it's very crucial to understanding our system of government. All right, that's all I got to say, guys. Again, thank you for tuning in. Don't forget to follow me. Don't forget to look me up on Twitter at Uncle Jonathan TV or on X. I will be posting. The channel is growing and growing and growing. I was telling somebody I had 150% growth because if you go from 2 followers to 4, that's 100% growth. So anyways, you guys, just 1 or 2 of you guys, you are making us have tremendous growth here at this channel, and I'm going to stay dedicated to it. I'm going to keep posting. So if you like this kind of content, please support it. It's encouraging to me, helps me wake up, helps me do it, and I really appreciate it. And I really want comments. I want interaction. You guys can join me on Spaces. Y'all can, tell me I'm an idiot, tell me I don't know what I'm talking about. I want to hear these other points of views. I really do. because there's times where I'm just sitting here, right, talking to myself, talking to the camera, and sometimes I just get a little lost, or sometimes my train of thought gets lost, and I really do need somebody to kind of smack me upside the head. So I appreciate, guys. Y'all have a wonderful Thursday, a wonderful day. God bless you, God love you, and be nice to each other.